Uvaženi državni sekretaru, poštovani gosti, dragi prijatelji, veliko je zadovoljstvo i neizmerna čast biti na ovom mestu u ovom trenutku, zbog čega bih želeo prvo da se zahvalim svima onima koji su pomogli da se današnja konferencija održi na način na koji će se održati. Prvenstveno veliko hvala državnom sekretaru u Ministarstvu turizma, trgovine i telekomunikacije. Njegovo prisustvo u ovom skupu je veoma važno zbog uloge ministarstva i inspekcijskih organa u borbi sa nedozvoljenom trgovinom na internetu, a operativno najviša funkcija u hijerarhiji ministarstva pripada državnom sekretaru Urošu Kandiću. Nije retkost imati nekog od predavača kakve mi danas imamo na konferenciji, bilo gde u svetu pa i kod nas, ali imati takva tri eminentna predavača kao što ih mi imamo i to potpuno besplatno za posetioce, zaista je retka privilegija. Zbog toga želim da u ime organizacionog komiteta kažem jedno veliko hvala Oliveri Medenici, Dagu Isenbergeru i profesoru Robertu Garza Barbosi. Njima posebno hvala i što su zbog vremenske razlike danas ovako rano morali da ustanu. Respected State Secretary, distinguished guests, dear friends, it is great pleasure and immense honor to be at this place at this time, which is why I would like to first thank all those who helped to hold today's conference in the way it will held. First of all, a huge gratitude to the State Secretary of Ministry of Tourism, Trade and Telecommunications. His presence at this gathering is very important due to the role of the ministry and inspection bodies in the fight against illegal trade on the internet, and the highest operational function in this hierarchy of the ministry belongs to the State Secretary Uroš Kandić. It is not uncommon to have one of the lectures like we have today at conference anywhere in the world or in Serbia, but to have such a three-eminent lecture as we have today and completely free of charge for audience, it's really a rare privilege. That is why I would like to say on behalf of the conference organizing committee, thank you very much, Olivera Medenica, Dag Isenberg, and Professor Roberto Garza Barbosa. Especially, thank you for getting up so early. Sada će, s obzirom da nam je dekan Pravnog fakulteta Univerziteta Union službeno odsutan, čuti pozdravnu njegovu reč.
U saradnji sa nekoliko advokatskih kancelarija koje se bave pitanjima zaštite podataka i pružanju usluga u ovoj oblasti, kao i našim dugogodišnjim partnerom i saradnikom Fondacije Registra nacionalnih domena Republike Srbije. Osnovni zadatak i osnovni cilj je zaštita pre svega podataka o ličnosti, dobrog poslovanja i uopšte ljudskih prava. Mi smo već nekoliko godina sa našim partnerima organizovali ovakve skupove i aktivno u pre svega edukovanju naših studenata koja prava mogu biti ugrožena savremenim tehnologijama. Takođe, zadovoljstvo nam je da se ova znanja šire i u okviru pravne klinike koja radi na našem fakultetu, ali i da možemo da damo svoj doprinos opštem povećanju nivoa znanja o zaštiti prava. Ovogodišnji skup ima jedan osnovni zadatak koji proističe iz samog naziva, dakle, zaštita u slučaju nabavki i elektronskog poslovanja. To je jedno od najatraktivnijih pravnih pitanja trenutno, s obzirom na okolnosti da se uvođenjem novih tehnologija postavljaju uvek pred nas i nove dileme i novi izazovi. Neka stara svojstva krivičnih dela, poput mesta gde je krivično delo izvršeno, zatim broja ljudi prema kojima se jedna protivpravna radnja sprovodi, se kod savremenih tehnologija potpuno gubi. Dakle, fizička udaljenost između izvršioca krivičnog dela i onog prema kome je krivično delo učinjeno, zatim mnoštvo ljudi prema kojima se određena krivična dela čine tako što se puštaju različiti podaci ili se daju lažni podaci, to je sve nešto o čemu ćemo u toku današnjeg skupa detaljnije razgovarati. Sa osobitim zadovoljstvom želim da predstavim našeg profesora Marija Lukinovića, koji će preuzeti rukovođenje ovim skupom, koji će najaviti ostale učesnike i one koji će voditi paneliste, a u moje ime još jedan puta vas pozdravljam i želim vam puno uspeha u radu i ličnu sreću.
Direktor Fondacije RNIDS Dejan Đukić službeno je odsutan zbog poslovnih obaveza na Internet Governance forumu u Katovicama u Poljskoj, ali nam je on uputio pozdravnu reč.
Dobrodošli na još jednu konferenciju o organizaciji Pravnog fakulteta Univerziteta Union i Fondacije Registar nacionalnog internet domena Srbije. Ovom prilikom želim da pozdravim Pravni fakultet kao domaćina ovog skupa i sve učesnike. Ovo je treća konferencija sa sličnom tematikom koje zajednički organizuju ove dve institucije. Drago nam je da je interesovanje za opšte i stručne javnosti za ove teme ne manjka ni malo. Ove godine smo rešili da iskoristimo sve prednosti koje pružaju onlajn konferencije i sa nama imamo sjajne predavače iz inostranstva. Ovom prilikom ćemo imati zadovoljstvo da od ovih predavača čujemo kako su određena pitanja kada je povreda prava u pitanju rešena na njihovim državama i kakve su prakse i iskustva sa kojima su se oni susretali. Potom ćemo imati priliku da kroz panel diskusiju čujemo i domaće stručnjake na temu regulative i prakse vezano za ovo pitanje. Nadamo se da će vam se program konferencije svidjeti. Hvala što ste sa nama i ove godine.
Hvala profesoru Šarkiću, hvala direktoru Fondacije RNIDS, a sada bih zamolio državnog sekretara u Ministarstvu turizma, trgovine i telekomunikacija, gospodina Uroša Kandića, da se obrati skupu. Izvolite.
Radi mikrofon. Uvaženi učesnici konferencije, poštovani članovi akademske javnosti, advokati i ostali prisutni, dragi prijatelju Mario, čast mi je zadovoljstvo da učestvujem na konferenciji koju ste organizovali danas na vašem fakultetu, tim pre što je tema o kojoj se govori danas izuzetno popularna, značajna i apsolutno u trendu kada su u pitanju nove tendencije u trgovini. Zadnje 2 godine imamo pandemiju virusa korona, odnosno bolesti COVID-19, koja je promenila svet u mnogome, promenila potpuno reljef ekonomija sveta, a jedna od privrednih grana koja je možda i najviše pretrpela promene u novonastalim okolnostima jeste trgovina, pogotovo u Srbiji. Naime, mi smo od zemlje sa pretežno tradicionalnim oblicima trgovine u poslednje 2 godine imali apsolutnu ekspanziju elektronske trgovine. Iako uzmemo da je 2019. godina na neki način nulta godina ekspanzije elektronske trgovine, mi ćemo vidjeti da smo te godine imali 7 miliona transakcija, 2020. dakle prve godine COVID-a duplo više, 14 miliona, a samo za prva 3 kvartala ove godine imamo 18 miliona, a neki nezvanični podaci ukazuju da do današnjeg dana da smo imali čak 18 miliona internet transakcija. Kada se pogleda koji su to iznosi u domaćoj valuti, u dinarima, mi smo 2019. godine imali 17 milijardi dinara transakcija, godinu dana kasnije 32 milijarde, faktički skoro duplo, a za prva 3 kvartala ove godine 38 milijardi dinara. Takođe, ako pogledamo broj internet prodavnica koje beležimo prema našim evidencijama, mi smo imali 2016. godine svega 300-tinjak, danas je 10-struko više. Podaci regulatora RATEL-a ukazuju i da je u 2020. godini, dakle prošloj godini, za 50% porastao broj prometa i broj ekspres pošiljki koje su cirkulisale na tržištu Srbije. Dakle, na taj način, kao što vidimo, ekspanzijom elektronske trgovine stvorio se jedan veliki hub i za ono o čemu mi danas govorimo, a to je nelegalna trgovina na internetu. Iako ne možemo sa sigurnošću da kažemo da je uduplavanjem elektronske trgovine dvostruko više i povećan broj nelegalne trgovine, ne možemo da se usudimo to da kažemo, svakako možemo reći sa velikom sigurnošću da je najveći deo nelegalne trgovine na internetu zapravo na društvenim mrežama. Zbog lakog otvaranja profila, zbog slabe kontrole, zbog toga što danas možete otvoriti profil, a sutra ga ugasiti, mi imamo trend bujanja nelegalne trgovine na društvenim mrežama. I naši su inspektori u ovoj godini i naravno i prošloj vredno radili i fokusirali se posebno na tu oblast, znajući da je u ekspanziji elektronska trgovina i skenirano i identifikovano više od 15.500 prečešljano, da kažem, kolokvijalno rečeno, oglasnih poruka na kojim se oglašavala prodaja pre svega duvana, obuće, odeće, kozmetike, alata, kućne hemije i drugih, i ustanovili smo da od tog broja čak više od 13.000 oglasnih poruka koje se tiču neregistrovanih trgovaca i krivotvorene robe. Naravno, mi smo u saradnji sa drugim institucijama državnim, pre svega sa tužilaštvom za visokotehnološki kriminal, sa MUP-om, neke od njih procesuirali, neke uputili njima, a neke smo i mi sami procesuirali u odnosu na težinu učinjenog dela. U našem radu nam uveliko pomaže zakonska regulativa koja je u dobroj meri usklađena sa evropskim standardima, da danas elektronsku trgovinu faktički mi kontrolišemo putem nekoliko zakona, dakle Zakon o trgovini, Zakon o elektronskoj trgovini, Zakon o zaštiti potrošača, Zakon o oglašavanju, Zakon o poštanskim uslugama. Dakle, sva celokupna ta regulativa iz određenih segmenata pokriva oblast i smatramo i verujemo da smo je na dobar način pokrili. Šta je važno da znaju sami potrošači, odnosno građani Republike Srbije kada je u pitanju trgovina putem interneta? Veoma je važno da se to obavlja, odnosno da se te vrste transakcija između potrošača obavljaju sa registrovanim trgovcima. Kako će ga prepoznati da je registrovan? Dakle, pored osnovnih podataka koje mora imati svako pravno lice, uključujući poslovno ime, šifru delatnosti, PIB broj, elektronsku poštu, broj telefona i tako dalje, imaju dva obrasca koja se tiču, jedan se tiče odustajanja, prava na odustanak u roku od 14 dana od kupovine i prava na reklamaciju. To su zapravo stvari, vododelnice koje odvajaju legalnu od nelegalne trgovine na internetu i samo ukoliko potrošači budu vodili računa da sa ovakvim pravnim licima obavljaju svoje transakcije, možemo ih zaštititi. I mogu reći da su, kada pogledamo zakonsku regulativu, naši potrošači, mogu reći slobodno, znatno zaštićeniji u elektronskoj trgovini nego kada je u pitanju tradicionalna. Ja ću podsjetiti da imaju pravo na odustanak od kupovine bez obrazloženja u roku od 14 dana od kupovine određenih proizvoda preko interneta. Takođe imaju pravo i na 2 godine od momenta kupovine reklamaciju na nesaobraznost proizvoda. Dakle, to su veliki benefiti, ali uslov svega je da se kupuje kod registrovanih trgovaca. Ono što treba takođe pomenuti, a malo pre sam ga apostrofirao, jeste Zakon o poštanskim uslugama iz 2019. godine, gde je uvedena obaveza identifikacije pošiljaoca određenih proizvoda prilikom isporuka kurirskoj službi, jer smo u ranijim situacijama imali usled neidentifikovanosti velike probleme da utvrdimo ukoliko je nelegalna roba poslata, faktički nismo mogli ući u trag. Uopšte sada to možemo. Ja ću samo da pomenem jedan zanimljiv slučaj koji se desio recimo 2018. godine, da smo imali situaciju da je u jednoj pošiljci bila poslata zmija, dakle, od neregistrovanog pošiljaoca poslata je zmija. Možete misliti kakav je šok izazvalo to i kod onoga ko je primio i kod ostatka javnosti kada je preko medija to čula. Dakle, kada je u pitanju nelegalna trgovina, značaj njenog što većeg suzbijanja je veoma bitan. Pre svega jer nelegalnom trgovinom i njenim afirmisanjem gube svi, dakle, gube potrošači, jer su proizvodi uglavnom koji se na nelegalan način putem interneta prodaju uglavnom i nebezbedni. Dakle, nisu originalni, mogu biti nebezbedni, nemaju određene sertifikate, rizik su za potrošače. Država gubi jer veliki deo novca odlazi u sive tokove. Danas sam baš pričao na konferenciji povodom twinning projekta o intelektualnoj svojini da 5,8% uvoza u Evropsku uniju otpada na falsifikovanu robu. To su ogromne količine. 2,5% otprilike svetske ukupne ekonomije se na neki način odnosi na falsifikovane proizvode. Dakle, to su ogromne sume i na kraju, kao što gube i potrošači, kao što gube i država nelegalnom trgovinom na internetu, gube i sami trgovci, jer se stvara na taj način nelojalna konkurencija i u tom lancu nema dobitnika. U krajnjoj liniji, kada se sve podvuče, ukoliko ne budemo ovaj problem na ozbiljan način tretirali, svi smo na gubitku. Tako da i pozdravljam današnje održavanje konferencije i zaključke koje ćemo doneti svi na kraju. Mislim da će biti dragoceni u našim daljim aktivnostima na ovom planu. Hvala vam puno.
Još jednom veliko hvala državnom sekretaru, pre svega na ovim zapažanjima i iznošenju svega onoga što opterećuje rad onih koji žele da regulišu nedozvoljenu trgovinu na internetu. Dejan Đukić je rekao da je ovo već 3. konferencija za redom, ja moram da ga ispravim, 3. kako on i ja učestvujemo, a 6. koju za redom Pravni fakultet Univerziteta Union i zajedno sa Fondacijom RNIDS organizuje. Organizacioni odbor konferencije ove godine je želeo da promeni kurs, dosadašnji kurs konferencije, i da ona bude usmerena od naučne ka stručnoj i ka promatranju sporovođenja zakonske regulative i primjerima iz prakse. Svesni značaja komparativne analize i empirijskih iskustva, smatrali smo i da konferencija treba da bude, odnosno da pokuša da bude jedinstveno mesto na kome će svi oni koji se bave različitim videovima interneta imati priliku da iskažu svoje stavove, postave pitanja, razmene iskustva i znanja, kako bismo zajednički generisali znanje koje će svima biti koristan oslonac u svakodnevnom radu. Savremeno pravo se našlo pred teškim izazovom, a to je da treba da u što kraćem vremenu i na što bolje način apsorbuje strahovito brze promene koje se dešavaju u sajber prostoru. Procenjuje se da je samo u 2019. godini 1,9 milijardi ljudi kupilo robu ili usluge putem interneta u vrednosti koja premašuje 3,5 biliona američkih dolara. Udeo elektronske trgovine u ukupnoj globalnoj maloprodaji u nesprestanom rastu i očekuje se da će 2023. on dostići 22% ukupne svetske trgovine. Glavna karakteristika interneta su njegova globalna dostupnost i otvorenost, što ga takođe čini i posebno ranjivim. Zbog toga i u Republici Srbiji kod velikog broja korisnika još uvijek postoji bojazan od onlajn kupovine. Teme koje su odabrali današnji predavači, svaki iz svog rakursa, obrađuju pojedine aspekte složenog problema nedozvoljene trgovine, dajući nam kompletniju sliku teme kojom se danas bavimo. Pandemija nas je okola na mnogo načina, ali je otvorila neke nove vidike. Moć online platformi pružila nam je mogućnost da uspemo da pridobijemo zaista vrhunske predavače iz Sjedinjenih Američkih Država, Daga Isenberga i Oliveru Medenicu, i Meksika, profesora doktora Roberto Garza Barbosu. Svesni nedoumica koje opterećuje kako korisnike interneta, tako i praktičare, nakon predavanja predvideli smo panel diskusije iz koje će kolege advokati Dragan Milić iz advokatske kancelarije Milić, Vladimir Marenović iz advokatske kancelarije Živko Mijatović & Partners i Nenad Cvjetićanin iz advokatske kancelarije Cvjetićanin & Partners probati da daju odgovore na dileme iz prakse. Sada bih želeo da predstavim kratke biografije današnjih predavača, ne zbog toga da bih vam ih preporučio, već da bih im zahvalio što našu pravnu i internet zajednicu obogatili današnjim predavanjima. Olivera Medenica je partner u advokatskoj kompaniji Dunnington Bartholow Miller. Predavala je u Udruženju advokata okruga Njujorka, Advokatske komore Njujorka, Advokatske komore države Njujork, Pravnom fakultetu Univerziteta Harvard, Pravnom fakultetu Univerziteta u Brooklynu, takođe u školi vizualnih umetnosti na Manhattan School of Music, Njujorškoj fondaciji za umetnost i brojnim drugim fakultetima i akademijama. Koautor je 5 knjiga iz oblasti intelektualne svojine, Navigation Fashion Law u izdanju Thomson & Reutersa 2015. American Bar Association Legal Guide to Fashion Design iz 2013. The Business and Law of Fashion and Retail, Carolina Academic Press iz 2020. Routledgeovo izdanje Copyright and Creativity in 21st Century, Taylor and Francis Group i tako dalje. Prvi, Doug Isenberger, advokat i osnivač Giga Law kompanije, predstavit će predavanje čiji je naslov Trendovi u sudskim sporovima u vezi internet domena i studiju slučaja. On je osnivač kompanije Doug Law Firm i priznati lider u oblasti internet prava. Česti autor i govornik o internet pravnim pitanjima, radio je kao vanredni profesor prava interneta i cyber prostora na Atlanta Business Chronicles ga je nazvao međunarodnim autoritetom za internet pravo. Uključen je u izdanje najboljih advokata u Americi za tehnološko pravo za 2021. godinu. Doug Law blog je od strane ABA žurnala prepoznat kao jedan od 100 najboljih blogova za pravnu publiku i zaslužuje stalno mesto u kući slavnih najboljih pravnih blogera Expert instituta. Profesor Roberto Garza Barbosa je profesor intelektualne svojine i međunarodnog privatnog prava na Univerzitetu de Monterrey u Meksiku. Član je izvršnog odbora Međunarodnog udruženja za unapređenje nastave i istraživanje u oblasti intelektualne svojine ATRIP sa sedištem u Cirihu. Takođe je bio član Komiteta za oblast nauke i društva Latinoameričkog programa za nauku, tehnologiju i razvoj sa sedištem u Madridi. Na Fakultetu tehnologiko de Monterrey je nacionalni predstavnik strateške istraživačke grupe za pravo i pristup pravu. Objavio je 5 knjiga i veliki broj istraživačkih članaka u indeksiranim akademskim časopisima. For the 6th year in a row, the Faculty of Law of the Union University, together with the Foundation Registry of National Internet Domains, is organizing this conference. The organizing committee of the conference wanted to change the course of the conference this year and to direct it from the scientific to professional and to observe the implementation of legislation and example from practice. Aware of the importance of comparative analysis and empirical experience, we believe that the conference should in the future try to be a unique place for all those who deal with the different type of internet will have the opportunity to express their views, ask the questions, exchange knowledge and jointly granted knowledge that will be a useful support for anyone in their daily work. Modern law is facing uniquely difficult changes, and that is that it should absorb the incredibly fast change that are happening in cyberplace in the shortest possible time and in the best possible way. It is estimated that in 2019, 1.9 billion people bought goods and services online, worth more than $3.5 trillion US dollars. The share of e-commerce in total global retail is constantly growing, and it is expected that in 2023, the share of e-commerce will reach 22% of total world trade. The main characteristic of the internet are its global accessibility and openness, which is also makes it especially vulnerable. DRIF In the Republic of Serbia, a large number of users are still afraid of online shopping. The topics chosen by the lecturers, each from its own perspective, deals with the certain aspects of the complex problem of eliciting trade, giving us a more complete picture of the topic we are dealing today. The pandemic has shackled us in many ways, but also opened up some new sight. The power of online platform gave us opportunity to succeed in getting really top lectures from US, Doug Isenberger and Olivera Medenica, and Mexico, Professor Roberto Garza Barbosa. Aware of the dilemmas that burden both internet users and practitioners, after the lecture, we planned a panel discussion in which fellow lawyers, Dragan Milić from the law office Milić, Vladimir Marenović from the law firm Živko Mijatović and Partners, and Nenad Cvjetičanin from the law office Cvjetičanin and Partners, to provide answers to dilemmas from the practice. Now, I would like to present short biographies of today's lectures, not to recommend them, but to you, but to thank them for encouraging our legal and internet community with the lectures today. Olivera Medenica is equity partner at Dunnington Bartholow Miller and is member of its intellectual property, privacy, advertising, art and fashion law, international and litigation and arbitration practice group. Olivera is also a member of Dunnington executive committees, chairs its trademark practice group, privacy practice group, as well as its diversity committee. She is also co-author of 5 books in the field of intellectual property: Navigation Fashion Law by Thomson Reuters, 2015 edition, the American Bar Association Legal Guide to the Fashion Design, 2013, Business and Law of Fashion and Retail, Carolina Academic Press, 2020, The Routledge Companion to the Copyright and Creativity in the 21st Century, published by Taylor Francis Group, and the Fashion Designer Several Guide. Doug Isenberger, an attorney and founder of the Giga Law firm, Doug Isenberger is recognized leader on internet law, a domain name panelist, as a frequent author and speaker on the internet legal issues. He has also served as an associated professor of computer and cyberspace law. The Atlanta Business Chronicles has called him as international authority of the internet law. He is included in 2021 first edition of the Best Lawyers in America for Technology Law. During ICANN expansion of the domain name system in 2012, Doug represented trademarks owner and domain name applicants in the objection proceedings. Doug's Giga Law blogs has been recognized by the ABBA Journal as one of the top 100 best blogs for the legal audience, and he has earned a permanent place in the Expert Institute Best Legal Blog Hall of Fame. And for the last, Professor Roberto Garza Barbosa is the Professor of Intellectual Property and Private International Litigation at Tecnológico de Monterrey. He is Executive Committee member of the International Association for Advancement of Teaching and Research in Intellectual Property, ATRIP, based in Zurich, Switzerland. He's also been a member of the Committee of the Science and Society area of the Ibero-American Program for the Science, Technology and Development, based in Madrid, Spain. At Tecnológico de Monterrey, he is a national chair of the Strategic Research Group of Law and Access to the Justice. publish 5 books and a good number of research articles in various indexed academic journals. Sada bih reč dao, čini mi se da nam se prvo uključuje koleginica Olivera Medenica. Je ona prva ili... Hello.
Hello, how are you?
Fine, thank you. Greetings for your Serbia. We are very glad to have opportunity to get knowledge and that you share especially the part from your well-gradated practice.
Thank you so much. And first of all, I want to thank everybody for including me on this discussion. And in particular, Vladimir Marenovic, who was kind enough to invite me. It's really an honor to be included in this conference, and it is actually my birthday today, so I couldn't think of a better birthday present than to be included in this conference. It truly is an honor. I do speak Serbian, but badly, so I prefer to speak in English, and so if you bear with me, I understood everything that was said in Serbian in the opening remarks, but my English, I would say, is far better. So the topic of my presentation is counterfeit products sold online, or trademark infringement online, which might not necessarily be counterfeit products all the time, but it certainly encompasses that. And just to give you a little bit of background about what I do, I'm an attorney based in New York, in Dunnington. You can see New York in the background. And a lot of what I do in my practice relates to representing larger brands, usually in the fashion industry, who have to deal with counterfeits of their products being sold on online platforms. And so what I'm talking about today really falls very squarely into what I do on a daily basis. So the title of my presentation focuses on Tiffany versus eBay. And so why are we discussing this now? And as I believe it's the secretary who made some remarks earlier today, the number of counterfeit goods and counterfeit sales that have occurred since the beginning of the pandemic, it has really been astronomical. But certainly this is a problem that predates the pandemic, but it has been, of course, been exacerbated by the pandemic. It is a worldwide problem. It is clearly a problem in Serbia. It's a problem in the United States as well. And it has been 10 years since Tiffany versus eBay. And Tiffany versus eBay, if you're not familiar with that case, Tiffany versus eBay is the case that really addresses how to impose liability on an online platform for the sale of counterfeit goods online. And so the question is, it has been a long time, and Tiffany versus eBay has been criticized, and I'll go over what happened in that case. Has Tiffany versus eBay been eroded over time? Is the holding of Tiffany versus eBay a fair or an unfair one? Should we impose more liability upon e-commerce platforms, or should we keep the status quo? And I think that's a discussion that has been a hot button in the United States, certainly a lot more in the past year, given the pending legislation and the re-examination of that standard. So in the United States, what I'm going to do is I'm going to go over the background of what's called contributory trademark liability. You have direct trademark infringement, which is I'm selling counterfeit goods and I'm liable for trademark infringement. And then you have secondary trademark liability or contributory trademark liability. And that's what these e-commerce platforms have. So in the United States, there are two types of secondary infringement claims. There's what's called contributory infringement, which is when a defendant induces or knowingly enables or assists an infringement. And so that liability for that defendant is going to depend on the level of involvement in the infringement. So that's contributory liability. And then there's vicarious infringement, when the defendant has a close relationship with the infringer. So in an agency type relationship, or where there is a shared control over the infringing goods or services. So whenever you're looking at secondary trademark infringement, like contributory or vicarious infringement, you first have to prove that there is a direct infringement in the first place. So without the direct infringement, you can't prove the secondary infringement. So why would a plaintiff sue somebody who's doing secondary infringement, but not necessarily the direct infringer? And there are many reasons strategically to do that. At least from the United States perspective, and I presume it's the same in other countries, sometimes the secondary infringer is a larger defendant with a deeper pocket, more money. So you might be looking at an e-commerce platform, and the infringers are individual sellers that are selling products online. So it's going to be very difficult and very costly to sell all of these individual infringers. It's more central to sue the e-commerce platform. And then the other reason, of course, is that the direct infringer is out of reach. They're located overseas. So it's very difficult for a US control to have an enforcement mechanism against that defendant, to control them, or to have jurisdiction over them. So there's different, very valid strategic reasons to sue a secondary infringer. And so when you're looking at the standard for secondary trademark infringement liability in the United States, that standard comes from a case from the United States Supreme Court from 1982. And I provided some materials, and there's a little outline that I provide of my talk so that you can kind of orient yourself about these cases and what I'm talking about. But the big Supreme Court case, so the United States Supreme Court is the highest court in the land. Whatever the Supreme Court says, of course, it's the law of the land, and everybody needs to follow it. But the Supreme Court said in this Inwood Labs case versus Ives Labs, the Supreme Court established a standard for secondary infringement liability. And in that case, I'll give you just very briefly a background of what happened there. The defendant was manufacturing some generic drug that looked a lot, it was pills, so it looked a lot like the plaintiff's pills. So let's say the pills were pink of a certain shape, it looked exactly like the plaintiff's pills. And so what the defendant was doing, it was marketing its generic version of plaintiff's pills to various pharmacists, and you had a catalog that goes with it and said, see, the pill looks the same, but we're much cheaper. So, hey, if you can use our pills instead of the plaintiff's pills, and here you go. And it looks the same. The consumer's not going to recognize it. And so pharmacists, as a result, ended up putting the generic drug and labeling it as the plaintiff's pills. And so that resulted, of course, in an infringement. And in this case, the court held, well, there's a party or a manufacturer or a distributor of an infringing product can be held liable for secondary trademark infringement liability if, number one, that defendant intentionally induced the primary infringer to infringe or supplied the goods to someone it knew or had reason to know was infringing, okay? So the first prong is this inducement. You induced somebody to infringe. And the second prong is, well, you supplied the goods to someone it knew or had reason to know was infringing. So there's a knowledge there, there's an inducement and a knowledge. And I think these two prongs are very important to keep in mind as we move along. The fact of the matter is, Inwood dealt with a sale of goods case, but courts in the United States have uniformly expanded that principle to services as well. So let's just take a look at this inducement prong. To show this inducement liability, what you have to show as a plaintiff, which is you have the burden of proof to do that, you have to show that there's some affirmative act on the defendant's part that encouraged this infringing conduct of the third party. So in your materials, I've included some cases that kind of give you a sense of what that would look like. There's, for example, a Pennsylvania court where you had a trademark owner's customer who convinced a third party to manufacture an infringing product. You have instances where a party created a script and gave it to a telemarketer and said, oh yes, this is the script that you have to use to promote my products, but in it, it included the plaintiff's trademark slogan. There is also a situation where someone was manufacturing generic paper towels, but really those generic paper towels were meant to replace the trademark owner's own branded paper towels in their products. There's also several cases relating to credit card processing services, and I'll go over them a little bit later. So these are examples of where you see some inducement, where a party is actively trying to encourage another person to infringe upon the plaintiff's mark. The other types of secondary infringement liability is where you're supplying something with knowledge of the infringement. So if you're looking at goods, for example, the courts have focused on the awareness of the conduct. Is the defendant aware that a third party might commit an infringement, or do they have actual knowledge of it? So if the defendant is aware that a third party might pass off the defendant's goods as that of plaintiffs, that certainly would have that knowledge requirement there. If the defendant is aware that a dealer might, for example, be misbranding a product as that of plaintiffs, that would certainly fall within that knowledge requirement. One thing that I want to say, though, is when I talk about knowledge, it sounds very amorphous, but it really is the plaintiff's burden to prove that knowledge. And so how do you prove the knowledge? You're only going to be able to do it through witness testimony, in depositions, or through documentary evidence. So if you don't have evidence showing that the knowledge is there, you're not going to be able to prevail on something like this. When it comes to services, and this is where we start seeing more cases relating to e-commerce platforms. As I mentioned, Inwood didn't just deal with goods, it also dealt with the sale of services. When you're dealing with a service provider like a web hosting or an online auction company, and this includes also e-commerce platforms, you have to look at whether this online entity, number one, directly controlled and monitored the means of the infringement, or number two, provided the service with knowledge of the specific instance of infringement that is the basis for the contributory liability. Okay, so there's a control aspect to it, and again, there's a knowledge aspect of it. And one thing I have to tell you about the United States, though, it's when you're dealing with a situation in the United States, it's extremely important to, and particularly on a topic such as this one, it's especially important to understand which court would have jurisdiction over the dispute. And if you have options, to take a look at case law governing this particular topic in various jurisdictions, because courts really do come out differently depending on where you are geographically in the United States. So for example, the Ninth Circuit, which is California, might come out differently than would a New York court. And conversely, the Sixth Circuit might come out differently. So it's very important to take a look at the dispute and understand that how a conflict between parties, where it is filed, will be governed by what the cases are in that particular geographic jurisdiction. And just because it's the United States doesn't mean that it's a uniform outcome everywhere in the United States. So I mentioned the two prongs when you're looking at a service provider is control, and the other one is knowledge. And when you're looking at control, a court really must find that a defendant directly controlled or monitored what's called the means or instrumentalities the third party used to commit the infringement. And so there are two factors that the court is going to look at is whether the defendant has sufficient control over the infringement to be able to stop and prevent it, and the public policy implications of imposing liability on a party in the defendant's position. So, for example, there's a very well-known case called Louis Vuitton versus Aconox Solutions. And there, the Ninth Circuit found that a web hosting company was liable for contributory trademark infringement where it provided server space to online infringers. And the court rejected the defendant's arguments, which said, well, no, the websites are selling the infringing products, not the servers. And the court said, no, you are providing to the defendant the means of continuing this infringement. And so the server company was the one that was held liable for contributory infringement. That being said, I do want to point out a few things about this case. A lot of times in the United States, the outcome of these cases are very much driven by how egregious the factual circumstances are in relations to the infringement. Here, in this particular case, while the holding of the case appears very broad, and it is, we have to keep in mind that the record reflected that there were 18 notices of infringement that were sent to the defendant by the plaintiff prior to filing suit. In other words, the defendant was notified on 18 separate occasions that there were infringements going on these websites, and the defendant did not respond and took absolutely no remedial action. And as a result, the jury awarded $10.5 million for contributory trademark infringement against each of the defendants. There was multiple defendants involved, and for a total of $31.5 million. The defendants appealed to the Ninth Circuit and they lost. So the liability is quite high, but in this particular instance, I think what happened factually is very telling because there was clearly a failure on defendant's part to respond to plaintiff's notices of infringement. The same kind of outcome was in this case that I have in the materials, Gucci versus Frontline Processing. And in that case, similar situation, the facts were quite egregious. But the holding really says that, yes, a credit card processing company that provides services to a website selling counterfeit goods can be held liable. But in this particular circumstance, the defendants were advertising themselves as available for high-risk merchant accounts. They were really placing themselves in the marketplace in such a way that they would be attractive to defendants selling counterfeit products. So they were really walking a very fine line. So in that case, the court held that they are liable. But there are other cases that also hold that a credit card service company is not going to be held liable. So it really depends on the factual circumstances of the case. And a court is not going to take kindly to a defendant that completely does not care about infringement, does not respond to notices of infringement, or is clearly advertising their services as catering to potential counterfeiters. And the second prong, so we have the knowledge. but the second prong is specific knowledge. And I'll make sure that I'm sorry, the first prong was control that I just went over. And the second prong is specific knowledge. And this is where Tiffany versus eBay falls. And this is the specific standard that is applicable in most instances to e-commerce platforms, which is of relevance to the discussion today. In Tiffany versus eBay, the court held that in order to impose liability on a platform like eBay or a social media platform, you have to show that this service provider knew of the specific infringing conduct underlying the contributory infringement claim, including the identity of the infringer, and continued providing the service without appropriate remedial measures. Okay, these two prongs are incredibly important, and that is our jurisprudence that we have in the United States. It's Tiffany versus eBay. Now, what happened in Tiffany versus eBay is Tiffany versus eBay followed the Inwood standard that I just spoke about. So it followed that 1982 Supreme Court case, the Inwood standard, right? I just spoke about that case with the drug manufacturers and the little pink pills and all of that. That is the standard that Tiffany versus eBay followed. And in this particular case, Tiffany, if you're not familiar with the background, but basically eBay was selling tons and tons of counterfeit products that were claiming to be Tiffany products, but that were not. Consumers were complaining about it. I mean, the volume was egregious. Tiffany had sent thousands of notices to eBay saying, hey, you're selling counterfeit products. I mean, very specific, hey, take this one down, and this one is infringing. I mean, it really was, the volume infringing products was tremendous. And what eBay did in this instance is, unlike the Akanok case that I just spoke about, or the credit card processing case that I spoke about, eBay took a very active role. And it responded to each of those notices, and it took remedial action. And so as soon as it knew of a particular case of infringement, it responded and did something about it. What Tiffany was essentially arguing was like, no, you've got generalized knowledge. It's not enough that you're taking something down when I told you about it. You have general knowledge that there's tons of infringement going on your site, and therefore you must be liable for contributory trademark infringement. And the court held no. Here, eBay did everything that it could. It responded to the infringement notice. It took the product down. It took remedial measures. Therefore, it's not going to be held liable. And so that's what we have right now. That is the jurisprudence that we have, is that the responsibility of making sure that there's no counterfeit products on the website is squarely on the brand owner. That is Tiffany versus eBay. While a e-commerce platform does have a responsibility to respond to a notice of infringement and take the product down, it doesn't have the responsibility to police its platform. However, because of the Tiffany versus eBay standard, where the court really took tremendous effort to underline that eBay took remedial actions, and that was an important factor, an e-commerce platform, therefore, is encouraged to take remedial actions. And that's what you see a lot of times in you have the eBay Verified Rights Owner Program, and most of these platforms that are selling millions and millions of goods have some kind of system in place to encourage brand owners to report infringements, to just have a forum to take things down. And they're usually quite responsive if you send them an infringement notice. But certainly the e-commerce platform does not have the responsibility of policing its platform for counterfeit goods. So what is it that a plaintiff needs to show under Tiffany? It needs to show that it sent a demand letter, that it identified the product, And that just the defendant actually had specific knowledge and did nothing about it. So I'm going to skip over some of the materials that I have so much that I wanted to cover, and I see that I'm running out of time very, very quickly. But I think I've kind of give you a sense of how strong the holding of Tiffany versus eBay is, and what is our current landscape with respect to secondary trademark infringement. So clearly, if you are a brand owner and you send that notice and the platform does nothing, the platform under Tiffany versus eBay is in trouble. Now, the other thing that I want to point out, which is I think is very important here. Actually, there's a couple more things, and then I'll stop talking, monopolizing the conversation. But it's important to note that Tiffany versus eBay addressed the situation where the other sellers were selling products online. As soon as the role of the platform changes and the platform becomes more involved in the sale of the product, so that it's not truly it's still an independent seller selling something online on that platform, but the actual online platform is more involved in that sale process, then the online platform really runs the risk of being accused of direct infringement. And there's a very well-known case that came out this year from the Sixth Circuit that's called Ohio State University versus Redbubble. And in that case, Redbubble is this online platform where it allows other sellers to sell their things there. So if for example, I wanted to order something from Redbubble, I would order, whatever product from those independent sellers, and the product would actually come to me, but it would come in the Redbubble package. It would be branded Redbubble, but the product itself is actually sold by an independent seller on the Redbubble platform. And the trouble that Redbubble ran into in the particular case is that the case was appealed to the Sixth Circuit. So it's another geographic region in the United States. And the Sixth Circuit said, wait a minute, I understand Tiffany versus eBay, but here Redbubble is really involved in the packaging, in how the products come into existence. Yeah, it's a third-party seller that's actually selling the product, but Redbubble is awfully involved in that process. And therefore, we think that Redbubble might be held liable. And what the Sixth Circuit did is it sent the case back to the trial court to determine the extent of Redbubble's involvement in the sales process. So I think this case is very important to understand that once a platform becomes involved in this, it becomes a different type of liability. And the reason I raise this is that you do see large brands, and I'm not going to name them, but large brands, like large retailers, mass market retailers, that have a separate platform. So you can go to the mass retailer and you can buy the goods. They have brick and mortar stores. You can buy socks there, etc. But they also have marketplaces. And in these online marketplaces, you can buy certain goods and they're still kind of branded like you're shopping at that retailer, but it's that retailer's marketplace. And when you're buying goods there, you have to understand, who's processing the payment, how is the package being shipped to you? Is it branded with that mass retailer's brand? Because once you start seeing those signs, the ability to go for a direct infringement claim against that retailer increases. And so that's what we're seeing with the Redbubble case. There's also a very well-known case from New York. It's the Real case. And Chanel sued the Real, and the Real is a consignment store. And I don't know if you're familiar with the Real, but the Real sells luxury goods, but that are that are secondhand. The problem here is that the real is taking physical custody of the products themselves, is setting the prices, is marketing the goods, and has a lot of control over how the products are being sold to the consumer, even though the actual product, they're not the actual seller of the product. And in this case, a New York court said, well, you know what? There might be a possibility that the real might be liable for direct infringement. So the way that the case is structured procedurally is it's not a final decision. It's just a very early preliminary decision that says, okay, the real might be held liable. So that's an important case to keep in mind. The other thing that I want to point out is many of these cases dealing with online platform liability never get to a final decision or final judgment because they settle beforehand. So what we're left is with cases discussing a denial of a motion to dismiss, or a case discussing a reversal of a summary judgment finding. In other words, it's a preliminary finding. We don't have a final finding on the case. So I hope I didn't confuse anybody, but I think it's important to bring up because many of these parties settle before there's a final judgment in the case. I do want to point out very briefly that there's a number of cases in the product liability sphere. So we're not talking about trademark infringement, but product liability sphere where the court said the online platform might be held liable. And the discussion is really very similar to what we have seen with the Redbubble case that I just spoke about, where as soon as the online platform is involved in the sales process or ships the goods or houses the goods in one of their warehouses, then they might be held liable for any injuries that occur as a result of a consumer's purchase of the product. In my view, many of those product liability cases tend to be brought in state courts, not federal courts. So the weight that a federal court might give to a product liability case is going to be obviously a lot less than a Tiffany versus eBay type of case. But I do see a trend in product liability cases for state courts to hold the e-commerce platform liable for injuries sustained by a purchaser of the product. And I have even seen cases where the platform did not even store the product in one of their facilities. It was shipped directly from China, for example. And these tend to be Amazon.com cases. So it really, in my view, it's a surprising outcome. And these are cases from California that I've noticed. And they tend to be very recent cases. So in my view, I think we're going to start seeing more willingness by state courts to impose liability upon online platforms via these state court cases. And perhaps we'll see an erosion of that reluctance to hold online platforms liable for trademark infringement that might follow after that. But really, it's too early to tell. I do think that the Redbubble case is very telling. The real case, also relatively recent, is very telling as well. So I do see a certain shift away from a very strict reading of Tiffany versus eBay in those types of cases. As a last closing point, I do want to point out in your materials, there are two pieces of legislations in the United States which might be of interest to, I think possibly in Serbia, to just track them and see what happens. And you may have similar legislation in Serbia. You may be well ahead of us. I don't know. But one of them is the Shop Safe Act, and the other one is the Informed Consumer Act. And the Shop Safe Act, I think, has a pretty good chance of being passed in the United States. It's not passed yet, but I think it has a pretty good chance. And it basically requires for e-commerce platforms that each third-party seller uses images that the seller owns or has permission to use or that accurately depict the goods. So it's a legislation that, you know, an online platform would have to follow. An online platform would have to implement a policy that requires termination of a third-party seller that has reasonably been determined to engage in repeated use of a counterfeit mark. The third-party seller has to consent to jurisdiction in the United States, and there needs to be verification of the seller, their principal place of business, the contact information of the seller, and any kind of material misrepresentation needs to lead to a termination of a third-party seller. And there are statutory damages that are, you can't recover less than $2,500, so $2,500, or more than $15,000 per notice. And if there's aggravating circumstances, not less than $15,000 or more than $75,000 per notice. So you can imagine that can add up over time. For the Informed Consumer Act, that one is a little bit more controversial. And there is a version in the House. So we have the House and Senate in the United States. There's a version of the Informed Consumer Act that's in the House, and there's another version that's in the Senate. And really what it requires is online marketplaces impose the affirmative duty upon them to verify high volume third-party sellers by requiring them to submit a government ID, tax ID, bank account information, annual certification, and contact information. And it needs to be, disclose this information in a clear and conspicuous manner on the product listing. High volume third-party sellers are defined as vendors who have 200 or more discrete sales in a 12-month period amounting to $5,000 or more. So it's pretty low threshold actually. You need to have a mechanism that allows for electronic and telephone reporting of suspicious marketplace activity. And if the third-party seller does not comply, then the online marketplace has the affirmative duty to terminate and to suspend the sale of this third-party seller. Now, one of those versions of the bill contains a clause that says that state attorney generals and the FTC can enforce this law. And that version is the version that e-commerce platforms are opposing. So that the version without that option of having state attorney generals enforce it is the one of obviously that e-commerce platforms approve of. So it's a watered down version that seems to have e-commerce platforms backing it. So I think, you know, from my perspective and my practice, I think it's a step in the right direction. But it certainly is a shift in how the United States has approached the Tiffany versus eBay standard. And I think you can tell based on the cases that I've covered and kind of the legislation that's pending, I think you can tell where jurisprudence in the United States is heading. So it's a slow process, but it seems that we're slowly, very slowly moving a little bit away from Tiffany versus eBay. So that kind of wraps up my presentation. I hope I didn't go on for too long, but that gives you a sense of what it's like in the United States when you're dealing with e-commerce platforms and secondary trademark infringement liability. So I don't know if we're taking questions, but I defer to you.
Thank you, Olivera. Before I give word to the public, if someone like to give you any questions, first of all, thank you really for very interesting presentation. It was great privilege to listen to your lecture. And if you don't mind, I would like to say that we are proud to have someone like you to represent us in the United States. Your professionalism and also your beauty, we like to address to your roots, our roots, you know. And now to audience, if someone have a question, Also, because of some organization questioned about the people who are present here. For the rest, there is open way to ask through chat over the Zoom platform or YouTube. I would present any question either to you or following lectures or at the panel discussion to our dear colleagues. Sada ako neko ima pitanje u publici ili preko diskusija u chatu, može da postavi pitanje, a bukvalno svako pitanje će biti kako kasnijim panelistima, advokatima postavljeno, tako i predavačima koji imaju sada predavanje. Izvolite. Izvolite, mikrofon, kolega.
Jel se čujemo? Pozdrav, Olivera. Jel se čujemo?
Da, čujemo se.
Bravo, bravo. Would you like me to ask you something in Serbian or in English?
Let's stick to English.
Okay, sure, no problem. Actually, I do have some questions. Is there any difference? Will there be any difference in safe harbor regime? Speaking of liability of e-commerce platforms, and the second question is you were telling us about the cases involving luxury brands, Tiffany, Chanel. The Chanel case actually reminded me on Coty case in European Union a few years ago. But I'm particularly interested in knowing, is liability of platforms the same, speaking of luxury brands and all other brands, or do you find any difference at the end?
It's a good question. The safe harbor, what you're talking about, I don't want to call it a safe harbor. I mean, it is, it's not like I don't know if you're familiar with the DMCA, that truly is like a safe harbor. It's a statutory safe harbor. We call it a safe harbor. If you follow it, you know, you're safe. What you're dealing with these e-commerce platform, it's case law. So it's case law that has said, okay, if you don't have specific knowledge and if you have taken remedial measures as soon as you know about it, then you're safe, I guess you could say. You're not going to be sued. Tiffany versus eBay is still good law. It has not changed. It's still good law. It has been such a foolproof way of, let's say if you represent an e-commerce platform, for example, it has been a complete foolproof way of evading liability. What I'm saying is that I do see some chips in that in some cases, which is a little bit unusual. With the Redbubble case, for example, I do see willingness for courts to kind of say, but wait a minute, this is a little bit of a different situation. So the safe harbor is there, but I do see some chips on it. With well-known brands, the issue is whether you have a trademark registration or this really applies for patents as well. If you have some kind of registration, you're going to have a very hard time approaching like an eBay or an Amazon and saying, I've got common law rights. Even if you do, you know, even if you've used your trademark for 30 years in the United States, you know, and it's very legit, it's very strong marks, right? But if you don't have that registration, you're going to have a very hard time dealing with one of those platforms. You have to come to a platform and say, here's my trademark registration, here's my design patent, this is my copyright. Take this, you need to take this material down. So if you have that, they will take it down. So I think in that process, from I have seen as much responsiveness from online platforms to a small client who's not well known as much with a well-known client. You know, even with a well-known client, sometimes the response is very spotty. I mean, I just literally a couple of weeks ago dealt with a major online platform, like a marketplace. And I sent, I don't know how many, hundreds of notices to them because one of my clients, who's a well-known client, yes, had design patents on something and it clearly was infringing. And it actually didn't, it sent me back a notice saying, gee, we're not going to take it down. And ultimately they took it down, I suppose because it went to legal and legal said, you're crazy, just take it down. But I mean, that is the absolute thing not to do under Tiffany versus eBay, which is like not take it down. I can't even comprehend what went in their mind to actually send me an email saying we will not take it down, because I have the design patent. I mean, it was such a clear violation of Tiffany versus eBay, but they did it. Ultimately, they took it down. But you know, even when my point is, even if you're dealing with a famous brand, sometimes the platform is just, for whatever reason, doesn't want to take it down. So it happens even for well-known brands. I hope I answered.
We have one question over Zoom platform. Also, we have one question over YouTube channel, but I will postpone that question to the part for the panelists because the question is about copyrights of photos, and because it's not the theme of our conference, but also it is to our distinguished lawyers question who are dealing with that kind of copyrights. So I think that is best to address that question to them. And for Olivera, the question is it legal to sell second-hand Chanel or Pandora, for example? That was
so the
question from the audience over the Zoom.
So is it legal to sell secondhand brands online? Is that what the question is?
Yeah, I thought so.
Yeah. Yes.
Or other online platform.
Yes. It is legal once you have the first sale doctrine. Once you buy your goods, you can sell them. There's nothing wrong with that. However, once you start using that brand to promote your platform, then you start getting into trouble. And although there's a law in the United States, unfair competition law. So once you start promoting your services as a online platform and relying upon famous brands to do so, you're kind of getting in their crosshairs. And there's an argument that could be made that you are engaging in some kind of unfair competition, or you're affiliating yourself with the brand when you shouldn't be affiliating yourself. The real situation is the problem there is that the Real was promoting the sale of Chanel goods, for example, and certifying that the Chanel goods were legitimate goods. And that's when it started getting into trouble, because they were counterfeit products. And consumers were buying products thinking they were Chanel products, but they were actually counterfeit products. And they were not getting the benefit of the Chanel brand name. They were diluting the Chanel brand name as a result. So that's the problem with the Real. It's not an open and shut case. And as I mentioned, the case holding that I was discussing is a refusal by the judge to grant a motion to dismiss, which is not a win, but it's not a lose either. Does that make sense? So I think, yes, you have the first sale doctrine and you're allowed to sell branded goods that you've legitimately bought. You're allowed to sell them online. That's true.
Thank you for answer. Is in audience, do we have? No? Okay, so, okay.
Hi, Olivera. Just not to forget, we all wish you a happy birthday. If we had known that before, perhaps we would have prepared ourselves much better. Maybe to prepare a birthday song or similar.
No.
Okay, many thanks for the explanation you have provided. It's very enlightening for us.
Thank you, my pleasure.
Enjoying the rest of your day in the name of our names. Again, big hugs and greetings from Serbia. Bye.
Thank you.
Sledeći predavač je već predstavljen, a to je profesor Roberto Garza Barbosa sa Univerziteta Tecnologico de Monterrey u Meksiku. On će nam pružiti komparativnu analizu problema globalnih korišćenja autorskih prava upotrebom interneta. Hello, dear friend Roberto. Greetings from Serbia. The floor is yours.
Thank you very much to the Union University School of Law. Thank you very much to Mario Lukinović for his kind invitation in participating in this great event. I really enjoyed the conference of our prior speaker, Olivera, and this is a great exercise of comparative law. What I'm going to do is to talk about copyright infringement, thinking that on the internet, you may have a global copyright infringement. And this is from the perspective of the copyright holder. And you have two paths to stop copyright infringement on the internet. One of them is very expensive, which is to going to the national court where the infringing materials are hosted. The other one is to pursue the legal path in your home country in order to try to stop that copyright infringement. And I will bring you two cases, one UK case and another Mexican, the second case is a Mexican case. It's a very simple approach in order to see the difference between the UK and Mexico, and also to see the application to the TRIPS agreement, Article 50, in order to pursue this injunctive relief. Deals with the infringement litigation of copyright and related rights in the Mexican legal context. Also, this litigation bears an extraordinary resembles the Mexican litigation to the case brought before the Superior Court of Justice, UK Chancellery Division, 20th Century Fox versus British Telecommunications. Those are different cases in different legal systems, but there are very similar cases, very similar approach taken by the plaintiffs' attorneys, and let's see what happened in each case. In both cases, preliminary injunctions were directed against internet service providers to prevent users from accessing an internet page whose content was alleged to infringe copyright and related rights. This litigation is of great interest because the Mexican Supreme Court upheld the constitutionality of statutory provisions establishing such preliminary injunctions without hearing the alleged infringing party. All right, and both litigations are based on TRIPS Article 50, which establish that judicial authorities or even administrative ones may issue preliminary measures designed to stop the infringement or to preserve evidence in copyright cases. So the second paragraph of Article 50 of the TRIPS agreement also establishes that such measures may be ordered without the hearing from the opposing party in audita altera parte, when there is a possibility of any delay is likely to cause irreparable harm to the right holder, or where there is a demonstrable risk of the evidence to be destroyed. Not all legal systems allows this kind of preliminary injunction in audita altera parte, because those measures can go against national constitutional principles of due process of law, depending on each national constitution. Now, our first case is the 20th Century Fox versus British Telecommunications. This lawsuit is known as Newsbeat 2, seems to be the continuation of another lawsuit previously carried out in the same country. And the first litigation, defendant Newsbeat Ltd, was condemned because it facilitated through discussion groups its users to make protected works available to other users. So we are talking also about secondary liability and not a direct infringement. Even the defendant did not directly commit an infringement. It was convicted based on a type of secondary liability established by the Section 16 of the Copyright Designs and Patents Act of the United Kingdom. The court determined that it was liable for authorizing and procuring those infringements, and then was sentenced, the defendant was sentenced, was condemned to compensate damages, and definitively ordered not to facilitate the infringement of plaintiff's protected works. So, as expected, it happens what I already told you. The defendant moved its operation to another country outside the foreign country, outside the United Kingdom. And this is relatively easy. And if we compare these actions, just take the server to another country, it is very easy. It is very cheaper. There is a global internet. There is a lot of technology, and it still is very expensive to bring an action to stop that infringement. You have to hire lawyers abroad. You have to solve too many problems, and it happens to be expensive. So even if it was hosted on a server located abroad, people in the United Kingdom could access the internet page. So faced with this circumstance, the owner of the infringed work could a third party who did not seek the infringement, but who facilitated it in the ordinary course of its operations, probably without knowing that. And we are talking about the internet service provider that provides internet access to the people who are going to see the copyrighted, the infringed works. So here the remedy sought was not damages, but the blocking of the said internet page. If successful, the plaintiff would repeat the same strategy against the rest of the internet service providers in that country, in the United Kingdom. So localized users in the United Kingdom could not access the Newsbeam page. Most of them, because this is a good approach, but sometimes people can hire a DNS service in order to process the information to a server that is located abroad. And in those cases, when they fake their DNS, this remedy probably will not be very useful. But the remedy, the first litigation, in this case, the Newsbeam case, was useless also. So there is not a perfect approach in these cases when we have a national protection, national court, and at the same time we have a global internet that where the information is flowing from one country to the other, and it's easily moved, relatively easy, and in an inexpensive manner. So before filing the lawsuit, the plaintiff asked the British Telecommunication to block the website, but BT refused to do so. It's not a trademark infringement case. We have the safe harbors in the European Union, and they have the safe harbor in the UK law. Please remember, we are not talking about trademark infringement like the prior speaker did. We are talking about a copyright case. But the principles remain very alike, even if the source of the law is different. The legal basis for the order to restrict access to Newsbeam's website was Section 97A of the UK Copyright Designs and Patent Act. The sections contain the specific requirements in order to issue this type of order against the internet service providers. The first requirement is that the internet service provider has actual knowledge of the infringement in question. This is the tricky one, and this is the requirement that is also present in other jurisdictions. But what is actual knowledge vary very, very, very deeply depending on each jurisdiction. In the United States, what I have seen is this actual knowledge. It's ridiculous. It has to be very, very specific. And the approach on the YouTube cases lead to a service called GroupShark that copyright holders had to sue using state copyright protection because the limitation of liability of the DMCA was so broad interpreted by the judges that, well, at the end of the day, they took down the GroupShark service. But again, we are not, we are talking about here a UK case. Now, the interpretation of what such knowledge means can vary enormously, as I mentioned. However, in this case, the court held that even the plaintiff's attorney accepted that he could not prove that BT had actual knowledge of the particular infringement of fish protected work. It also alleged that BT had a general knowledge of users and using Newsbeam 2 operators to to download infringing materials. And that general knowledge was enough to carry out the preliminary injunction against the BT, which was not intending to carry out the facilitation of infringing activities, but it is an internet service provider, and in its normal operations, they pass through too many information. With this, the court held the case satisfied the knowledge requirement required by Section 97(8) of the Copyright Designs and Patents Act of the United Kingdom to issue the order to restrict access to the Newsbeam website. So here, BT argued that the restraining order violated the European Union Directive on Electronic Commerce, Article 15, Paragraph 1, prohibiting internet service providers from monitoring information transmitted through their services. However, the court held that the order was not to monitor information passing through BT's servers, but it was a specific and limited obligation to restrict access to a given internet site in an automated manner. So they don't have to look out for all communications, just block one internet site. So this case was distinguished from a European Court of Justice case, Scarlett Extended versus Saban, where the purpose was to monitor every internet communication and then block any peer-to-peer transmission. So in that case, in the Scarlett Extended case, the European Court of Justice analyzed several directives, and I have here all of them, including the directive on the enforcement of intellectual property rights, which includes and the implementation in the European Union of TRIPS Article 50, which was implemented in the United Kingdom in the Section 97, Paragraph 8, that was the base of the issuance of the preliminary injunction. Okay, so very specific order, it is okay under this perspective. However, a general order to block, to monitor every transaction, every transmission, in order to block an entire technology was not okay. If we see these two cases, the British case, the Newsbeam 2 case, and the Scarlett Extended. So in Mexico, it happens more or less in the same way. Here in Mexico, we have two ways to go into litigation. It's a very, it's not common in all countries, and I think in Serbia is like that. It's a judicial litigation. It's separated from the executive branch. For in Mexico, we have an administrative litigations that takes place in the same office that grants patents and trademarks. You know, it's not a common thing. Not even the Copyright Office. No. It's in the Mexican Patent and Trademark Office, which is called INPI. It could go there and you have to start all over again in federal district court or even in a state trial court in order to get damages. So this is a litigation that does not provide for damages, only for fines, that the money goes to the government. But in copyright cases, this is only if you base your action on Article 231 of the Copyright Act, which establishes the infringements, copyright infringements in trade. Okay, but if you base your action in Article 27, which defines the copyright economic rights, you may start in a judicial branch trial court. It could be federal or it could be a state. And this is different than the United States, because in the United States, it's always a federal question case. In Mexico, we don't have that thing. Well, it is a federal question case, but if the plaintiff wants, he may start the action in a state court, because it's a private litigation. Okay, let's see the litigation in our case. We found several orders imposing preliminary measures in a procedure. All orders were decreed by the INPI, which is an administrative office that grants patents, trademarks, also solves infringing cases, infringing patent cases, infringing trademark cases, and also infringing copyright cases. And the orders, those preliminary injunctions were decreed against all internet service providers in Mexico. That was the approach. The plaintiffs, what they did was they sued the homepage that was facilitating the infringement, and it also sued all internet service providers. So what the plaintiff got here was total termination of the infringing activity at the beginning of the litigation. All right. Article 199(b)(1) of the Repeal Industrial Property Act is the central point to the resolution of preliminary measures that concerns us, since it indicates with precision the aspects that the plaintiff will have to demonstrate in order to get the preliminary injunction. I mentioned this is a Repeal Industrial Property Act because we have a new statute that entered into force last year. However, the same statutory provision, the equivalent statutory provision in the new statute says exactly the same, the new Article 345. So this is still good law. The new statute just accommodate a few things and also arrange and implement some obligations that we have in Mexico with our trade partners, the Canada and the US, with this new USMCA, which has a chapter, an intellectual property chapter, which historically is the biggest IP agreement, even regional, ever. It is a very comprehensive. It has lots of obligations, but that is another history, another conference, and another talk. Right. So let's get back to this preliminary injunction. The elements to get a preliminary injunction in Mexico are very simple. You have to prove ownership. You have to prove infringement, imminent infringement, possible harm, or possible loss of evidence. You have to present a security or bail in order to protect the other party if you lose the main case, and you have to provide the necessary information to identify the place of infringement. One of the plaintiffs, it was a very well-known Mexican composer that he was called Armando Manzanero. He was represented by a society of authors and composers, and he accredited to be the owner of the copyright by presenting several compact discs that contain the phonograms of the said musical works. So no registry was necessary here. He just put the CDs and that's it. He proved the ownership. There were also other foreign right holders as Warner Bros. Who proved to be the producer of the cinematographic work called The Last Samurai by showing the material support of the said work. So this DVD was shown, no registration needed. After demonstrating the existence of the copyright and also the ownership, the second point to be shown according to the injunctive decrees was the possible violation of rights, as well as the possibility of suffering irreparable damages. It was through a visual inspection carried out by INPI to the internet page. This was the page with this IP address, and they just saw all the infringing materials, and then the preliminary injunction was issued. But one of those internet service providers, which is called Alestra, filed a writ of amparo, is the legal resource in Mexico to combat those kind of things. The argument was the issuance of a preliminary injunction without previously hearing the party against whom the order is directed violated Mexican due process clause contained in Articles 14 and 16 of the Mexican Constitution. The first thing that the Supreme Court held was that even the measures are granted without a hearing from the counterpart, they must have certain requirements. So those requirements are helpful to sustain constitutionality of those provisions, statutory provisions. The Supreme Court also held that thanks to these requirements, the press being filed complies with the guarantees of security and legal certainty, due process clause of the Mexican Constitution. In addition, it held that the INPI may require that the bond be increased and that the preliminary measure does not mean to prejudge the responsibility of the defendant, but rather that it is a provisional and it can be modified. Finally, it held that the provisional measures are subject to the infringement procedure, the main infringement procedure. So the principle of legal certainty and due process is guaranteed because the party against whom this measure is directed can defend itself in the main infringing procedure. So the preliminary injunction is at the beginning of the procedure, but without hearing the party against it is directed, but this party has legal resources in the main procedure, and that's it. Thank you very, very much.
Estimado amigo, muchas gracias por una gran conferencia. Saludos desde Serbia. Hola, compadre.
¿Cómo estás, Mario?
And now, if someone in the audience have some question for distinguished Roberto, professor. Okay, thank you, Roberto. Keep in touch. And now, for the last but not the least, distinguished Doug Isenberger, who is attorney and the founder of the Giga Law firm. He will present lecture domain name dispute trends and case studies. Dakle, advokat i osnivač Giga Law firme Doug Isenberger iz Sjedinjenih Američkih Država će nam predstaviti trendove u sudskim sporovima u vezi imena domena i studije slučaja. Hello, Doug.
Great, thank you very much. Before I begin, I just want to make sure you can hear me and see me okay. Yes?
Yes.
Can you hear me and see me?
Yes, yes, of course.
Oh, okay.
The floor is yours.
Okay, just wanted to be sure I don't speak for 30 minutes without being heard or seen. So thank you. And I really want to say what an honor it is to be able to present today. And I look forward really to talking about one of my favorite topics, which is domain name disputes, a very important area of the law today worldwide. So I'm going to start in just a moment with an introduction to the topic and an overview of the UDRP, the Uniform Domain Name Dispute Resolution Policy. And then I will discuss some recent data related to domain name disputes, followed finally by a number of case studies that address some interesting and important topics in the area of the law that is so important to trademark owners and all brand owners on the internet. And then, of course, time permitting, I'm happy to take some questions as well. So let me make sure my slides are working correctly. I thought I would just begin by talking a little bit about what exactly is a domain name dispute, because I think while obviously this is a very important question, because while we may all recognize that these disputes often arise between trademark owners in a particular category of domain name registrants who are usually referred to as cyber squatters, the truth is that there's really no universal definition of cyber squatting. Cyber squatting is a term that was first used in the mid-1990s, and this word really arose before many trademark owners even recognized the importance of the internet and the potential problems that could be caused by the registration and use of something as simple as domain names that contain their trademarks or something similar to their trademarks. And in the early days of cyber squatting, and when I began first doing this work in the mid-1990s, one of the early questions was whether traditional trademark law even applied to domain names. You know, were domain names protected by trademark law? And if so, could trademark owners use the existing trademark laws to enforce their rights? This was a very unclear question some time ago. Because the sort of traditional concepts of trademark confusion, even trademark dilution, which was a new concept here in the United States at the federal level, and counterfeiting, it was unclear whether these laws could be used to address issues such as phishing, spreading malware, deceptive advertising, pornography, blackmail, and other scams, if you will, that started to arise on the internet and cause problems for trademark owners and others. So as a result, what we saw were really the creation of domain name dispute policies, the very first of which, or one of the very first of which at least, and the most important, is the UDRP that I will explain in detail in just a moment. for those who are not familiar with it. The UDRP is the Uniform Domain Name Dispute Resolution Policy. And so these policies were created really to address the issues that you see on the screen here. Uniformity, number one, because domain names are by their nature global, as are websites. And so therefore there was, a significant problem that trademark owners were facing in all countries with respect to cyber squatters who might be conducting their business in other countries. And this sort of gave rise to a competing issue of what jurisdiction applied, whose country's laws would apply. Simply because a trademark owner might be based, for example, in Serbia or in the United States. If the domain name registrant was located in a different country, maybe the victim or an online purchaser was located in a third country, to which country's laws would the cyber squatter be subject? And so that was also one of the issues that these domain dispute policies intended to address. And then also the dispute policies are intended to address a couple of the shortcomings of traditional litigation, at least, of course, here in the United States. It's pretty well known, as it is in other countries, that traditional litigation in court is a very time-consuming and very expensive process. And so the UDRP and the other dispute policies that have arisen to deal with these issues are, by their very nature, much quicker from start to finish and significantly less expensive, and therefore more attractive to trademark owners to deal with these issues online. So in 1999, ICANN created the UDRP. As I've said a number of times, this is the Uniform Domain Name Dispute Resolution Policy. It is certainly not the only domain name dispute policy, but it is sort of the granddaddy of domain name dispute policies, if you will, because of how long it has been around. The fact that it applies to the .com top-level domain, and that it has been used so many times by trademark owners through the years. As I said, it is essentially an alternative to trademark litigation. The policy was adopted by ICANN, the Internet Corporation for Assigned Names and Numbers, in 1999. The only fees, in addition to the legal fees, are a filing fee, which since the beginning of the very first UDRP case, which was administered by WIPO, the World Intellectual Property Organization, the first case was filed in 1999. The filing fee was $1,500 US dollars, $1,500 US dollars. And that fee has actually remained the same for more than 20 years. Legal fees are typically significantly less expensive as well. And that's in large part because the UDRP process is so rapid. About typically 2 months, I tell my clients to expect a decision about 2 months after filing a complaint. The only documents that are intended to be filed in a UDRP proceeding are the complaint and the response. And these are filed electronically. In a previous version of the UDRP rules, there was some difference in interpretation as to whether hard copies needed to be filed, but the rules have since been amended and all of the proceedings are conducted electronically. Unlike traditional litigation, there is no discovery, no motions, no hearings, no trial. And so that's why the important documents that are filed, the complaint, to begin the process, needs to include really all of the factual and legal arguments that the trademark owner wants to address. There are some exceptions for possibility of what are called supplemental filings in certain cases, but in general, as I tell my clients, expect to file a complaint and perhaps nothing else, literally nothing else, throughout the course of the proceeding. The remedy that a trademark owner is seeking in a UDRP case is simply a transfer of the disputed domain name. There are actually three potential outcomes that a UDRP panelist can reach. Number one would be an order to transfer the domain name to the trademark owner, or the UDRP panel could choose to deny the relief and let the current domain name registrant retain the domain name. In some rare circumstances, the third remedy is invoked, and that's cancellation of the domain name. Usually that would be if the domain name, if the trademark owner has specifically requested a cancellation of the domain name instead of a transfer. Frankly, I'm still confused after all these years why any trademark owner would want to go through the time and expense of filing a UDRP complaint simply to get the domain name canceled, because it can then be registered again by anyone else, and you may need to repeat the process. As I said, the UDRP applies to .com, which is obviously far and away the most popular top-level domain, but it also applies to all of the global or generic top-level domains, the GTLDs, and about 40 of the country code or CCTLDs have adopted the UDRP, which is really why trademark owners significantly favor the UDRP over any type of other enforcement activity. And as you can see on the screen here, Corporate Counsel magazine even referred many years ago to the UDRP as the preferred option for most trademark owners. So substantively, this one screen explains most of what you need to know, at least at a very high level, about the UDRP. It includes a three-part test. So in other words, these are the three things that you see on the screen here that a trademark owner bears the burden of proving when filing a UDRP complaint. Number one, the trademark owner has to show that the domain name is identical or confusingly similar to a trademark in which it has rights. And that first part of the test is actually, as you can sort of see, really itself two parts. The complainant has to show that it actually has trademark rights. Interestingly, it need not be a trademark registration. And then it has to show that the domain name is identical or confusingly similar to it. And I'll explore some of these issues in some of the case studies that I will be talking about in a few minutes. So the second element of the UDRP's three-part test is that a trademark owner has to show that the registrant of the domain name against which it has filed the UDRP complaint has no rights or legitimate interests in it. There are specific ways in the UDRP policy in which a domain name registrant could establish that it actually does have rights or legitimate interests. But this is an interesting concept because it puts the burden on the complainant filing the case to sort of prove a negative. And then the third, and in many, there is significant precedent that has been established by literally the tens of thousands of UDRP decisions over the past 2 decades that help better define exactly what bad faith is. So logistically, where are these complaints filed? Because as I said, this is a universal, a uniform, a global policy. ICANN has essentially accredited currently six UDRP service providers. WIPO, as I said a moment ago, the World Intellectual Property Organization, which helped to draft the UDRP itself. WIPO is the largest and most active of all of the UDRP service providers. So more cases are filed at WIPO than anywhere else. WIPO also publishes what it refers to as the WIPO overview, which is essentially a very extended question and answer or FAQ about the UDRP that itself is a document that both trademark owners and domain name registrants can cite and often do cite as authority in their UDRP filings. The second most active UDRP service provider, the National Arbitration Forum, or now known simply as the Forum, based here in the United States in Minneapolis, Minnesota. WIPO, of course, I should have said, is based in Geneva. The Czech Arbitration Court, based in Prague, is the third most popular. And then the other service providers that you can see on the screen here account for the remaining number of cases that are filed. And by the way, a trademark owner can elect to file a UDRP complaint at any of these providers. They all administer the exact same UDRP policy, and they all use the exact same UDRP rules. How they differ is that they each have their own set of supplemental rules. So topics such as the filing fees, the availability of supplemental filings, the word count or the page count, some of these procedural issues differ among the providers. So next, I just wanted to spend a few slides to talk about a little bit of the data and some of the trends and some of the statistics that we're seeing in the area of the UDRP. And personally, even though I've been practicing in this area of the law for 25 years, just not quite 2 years ago, I started publishing this Domain Dispute Digest, which coincidentally sort of began, just about the same time as the pandemic. And we've seen some very interesting occurrences in domain name disputes because of the pandemic. I'll talk about those in a minute. But some of the data that I'm now publishing on a quarterly basis is quite interesting. So let me just jump into that. And perhaps the most startling piece of data comes directly from WIPO itself. So this slide here does not represent all UDRP filings. Instead, this is a representation of all domain name dispute cases, which could refer to policies other than the UDRP that have been filed at WIPO, which again is the largest of the providers, all through the years since the first decision in the year 2000. And what's really fascinating is that you can see that the number of cases has been increasing steadily since 2013. And as a matter of fact, in the current year, 2021, even though we still have close to a month left in the year, the number of domain name dispute cases filed at WIPO has already set a record. And if this trend continues through the end of the month, 2021 may actually break that record by about 20%, which is, as I said, kind of really startling. I think that's due to a number of reasons. The maturity of the domain name dispute system itself, and as trademark owners and brand owners of all sizes are still frankly learning about the UDRP even after more than 20 years. The pandemic, certainly for the past almost 2 years, I think has contributed to this surge in domain name dispute filings. I'll explain why in a few slides. And then frankly, just kind of the growing amount of business that is conducted online obviously is contributing to the number of problems online as well. So this slide, I think, tells the story as to why the UDRP is so favored by and often used by trademark owners online. And that's because, as you can see, trademark owners win about 95% of the UDRP decisions. That is, about 95% of the decisions result in an order to transfer the domain name or domain names, because a UDRP complaint can relate to more than one domain name under the right circumstances, or to cancel the registration. And only in about 5% of UDRP decisions result in a denial. That is effectively a decision allowing the current registrant of the domain name to retain it. This data, by the way, is current in the sense that it reflects the filings across almost all of the UDRP service providers in this past quarter. So this does not represent, and this is true of the upcoming slides as well, filings through all time, but it's a current snapshot of what has happened in the most recent quarter, which I think is certainly indicative in large part as to what is going on in general. So this next slide, I think, is also really fascinating. As I said before, .com is certainly far and away the most popular top-level domain for domain name registrations in general. And it is also certainly far and away the most frequently disputed top-level domain. Traditionally, before the expansion of the top-level domain system in recent years, .com, .net, and .org were consistently the top three most commonly disputed top-level domains. But as you can see, at least in the past quarter, .xyz has now climbed to the #2 spot. Google's parent company, Alphabet, I think, helped contribute to the popularity of the .xyz top-level domain, as well as some other factors, because they're using it themselves. But as you can see, .com blows away all the rest of the other top-level domains. But each quarter, and this list kind of changes from quarter to quarter, you can see the various top-level domains, .shop, .info, .online. A number of these are new top-level domains under the ICANN system that are now appearing in UDRP decisions. And as I said a few moments ago, about 40 of the country code top-level domains, or CCTLDs, have actually adopted the UDRP as their own dispute policy. And so this slide shows all of those country codes that resulted in more than one UDRP decision in this past quarter. .co for Colombia consistently is the most popular CCTLD under the UDRP system, and I'm sure that's because of the similarity between the .co top-level domain and the .com top-level domain. So cyber squatters are often looking to create confusion, and so using the .co top-level domain is a way to do that. Next, again, this is just a snapshot from the past quarter, but I think it's really, really very interesting to see who is filing UDRP complaints and what industries are they in. And it is consistently true, and this is just a snapshot of who, really the most active trademark owners were in the past quarter, from Philip Morris in the tobacco industry to Morgan Stanley in the financial services industry. And as you can just look at the list here and see whether it's adult entertainment or technology or banking or e-commerce, trademark owners represent probably just about every industry that there is in filing UDRP complaints. And I think this is important because it shows that cyber squatters are frankly targeting anybody and everybody, and no trademark owner is immune online from cyber squatting, and fortunately can use these dispute policies such as the UDRP to their advantage. So as I said a few minutes ago, the pandemic has really created not necessarily a renewed interest, but as WIPO has said, really a surge in cyber squatting activity. And this happened pretty early on. On the screen now, this is an excerpt from a press release that WIPO issued over a year ago when it reached its 50,000th domain name dispute filing. And this was a bit of a milestone, and WIPO has issued a number of press releases talking about how it is handling, and I would say quite well, the domain dispute process during the pandemic, but also the fact that we have seen this surge of domain name dispute filings. I think that's in part, and I'll talk about a case in just a moment, we see literally domain names that contain the word coronavirus or COVID or vaccine. cyber squatters are nothing if not opportunistic. And so they are creating all sorts of COVID-related scams. And I think that's in part, at least, during the lockdowns that have occurred, in various countries and in various, parts of the world over the past more than a year and a half, as cyber squatters have been at home. Frankly, they've been looking for ways to make money also. And so I think, they look at ways in which they can use current events of any type to their advantage to increase their cyber squatting activity. But in general, we also just see a significant increase in the number of domain name registrations continually, year after year, quarter after quarter, is contributing to this significant increase in cyber squatting and therefore domain name dispute cases. So now, just in the couple of minutes that I have left, I will move very quickly to try to focus on as many of these brief case studies as possible. But again, this is an excerpt from an article in the Washington Post, also from last year, showing how cyber squatters were using the pandemic to their advantage. The very first coronavirus-specific UDRP case was for the domain name coronavirusgoogle.com. And as you can see from the slide, Google filed its UDRP complaint at the forum around the same time that here in the United States, the lockdowns were starting. This complaint was filed in March of 2020. So you should know that in general, UDRP complaints and other documents from UDRP proceedings are not publicly available. They're not published online. So, everything I know about this case comes from the decision itself. And it doesn't really say, the decision in this case really didn't say much about what was happening in this case, except, and I'll just quote, respondent uses the domain name to pass itself off as complainant online in order to redirect internet users seeking complainant's products or services to a website that has no affiliation with complainant, of course, being Google. So interestingly, in this case, as often happens in UDRP cases, the registrant or respondent did not submit a response. That's not unusual. And so this is what is called a default, although there's no such thing truly as a default judgment, as there often is in court. But in this case, the UDRP panelists actually refrained from issuing a substantive decision on the merits and instead agreed with the registrant's offer to settle and simply ordered a transfer of the domain name. Next up, this is an issue that is not new, but is really grown in importance in recent years for multiple reasons, and that's the use of privacy or proxy services. These services offer domain name registrants the option, sometimes for a fee, to withhold their names and contact information from the public WHOIS database. So as you can see here, this is an example of a domain name registered at GoDaddy, and the registrant name has essentially been redacted and is simply identified as registration private domains by proxy LLC. Domains by proxy is the name of a company that provides this type of privacy or proxy service. So the rise of these types of services means that trademark owners have to figure out how to deal with them. And fortunately, trademark owners can still file UDRP complaints even when the identity of the domain name registrant is masked by a privacy or proxy service. So as you can see here, this is from the WIPO overview that I referred to a few moments ago, that after a complaint is filed, if WIPO obtains through its sort of administrative compliance process information about the underlying registrant, they will then provide that back to the trademark owner with an invitation to amend the complaint, which could be very helpful. The same type of issue has arisen in the past few years since the arrival of the European Union's GDPR, the General Data Protection Regulation. And as a result of the GDPR, many domain name registrars, even without offering a privacy or proxy service, are not disclosing their customers' data. And there is this ongoing debate about whether and how trademark owners and others should have access to this data. But the general point is that still, a trademark owner might not know the identity of a domain name registrant before deciding whether to file a UDRP complaint. And as you can see here, WIPO has said, much like cases under the privacy and proxy services, where the UDRP complaint contains at least all of the information that's known to a trademark owner, then it would be proper to go ahead and file the complaint. I'm running up against the clock here, I know, with the amount of time. So let me just very quickly mention a couple of other cases here. And that is lookalike domain names. What I refer to as lookalike domain names are also very common. The domain name that you see on the screen here is not googlemaps.com, but instead it has substituted the letter O, the 2 letter O's in Google, for the number 0. So that it looks like Google Maps. And yes, nobody is going to actually type that domain name, but because cyber squatters often engage in phishing activity, they're essentially creating a domain name that, for example, in a link may appear to be a link, in this case for Google Maps, but instead if you click it, you get this series of pop-up windows that appear to be coming from Microsoft. And are not. In this case, the UDRP panel had no problem finding that the domain name was visually similar misspelling, they called it, to the Google trademark, and therefore ultimately ordered a transfer of the domain name. Internationalized domain names create the same issue, as you're certainly familiar, I'm sure, in Serbia. Not everybody uses the traditional Latin alphabet that we use here in the United States. And so the example here of the Instagram domain name substitutes an accented letter A for the real letter A. And there are lots of other tricks that cyber squatters use as well. And so again, even in the presence of these internationalized domain names, under the first element of the UDRP, panelists do not have difficulty finding them confusingly similar to the applicable trademarks. This next case does not raise any substantive issues, but I'm talking about it because it raises a very important procedural issue. This was a UDRP complaint that was filed by IBM. Obviously, IBM is a well-known trademark worldwide, but the domain name IBMhistory.com that some cyber squatter had registered led to the site that you see here, which really had sort of flashy mix of graphics and text related to such things as interest-free loans, and apparently also pornographic and gambling sites. So the issue in this case was what language should apply to the UDRP proceeding, because the UDRP rules say that the language of the proceeding shall be the language of the registration agreement, the registrar's registration agreement, subject to the authority of the panel to determine otherwise. And this is one of those cases where the panel did determine otherwise. So even though the registration agreement was in Chinese, IBM requested for the proceeding to be conducted in English, and the panel agreed in part because the domain name itself contained a word in English, history, in the IBMhistory.com domain name, and also because there was some English text on various parts of the website. This is just obviously a partial screenshot. I know I'm past my time now, but let me see if I can just quickly advance to a couple other cases I'll just mention briefly. What I refer to as employment scams using phishing activity have become somewhat popular. This is a case, I represent Intercontinental Hotels. This is actually one of the cases that I had filed. Hotel companies seem to be the victims of a lot of these so-called employment scams, where a cyber squatter will register a domain name, in this case, Intercontinental Hotel Florida.com, and then set up a website that may look like the actual hotel website, send out emails advertising non-existent jobs, and as you can see, request information from gullible applicants, such as a copy of your passport and a copy of your birth certificate, which obviously can be used for all sorts of identity theft. No presentation is complete these days without mentioning NFTs, or non-fungible tokens. If you are not familiar with them, and I am by no means an expert on NFTs, but yeah, they're a type of a digital asset that exists on the blockchain, the same tool that's used for tracking cryptocurrencies such as Bitcoin. And there has arisen, recently quite a market in the creation of and selling of NFTs for even tens of millions of dollars, US dollars. So of course, cyber squatters, again, looking for opportunities, are registering domain names that contain NFT. Morgan Stanley, in this case, was the trademark owner that filed this UDRP complaint. Morgan Stanley is a very well-known financial services firm. I believe this is the first UDRP complaint of its type that included NFT, and the point here is that the panel said that, despite the inclusion of the word NFT along with Morgan Stanley, it was still confusingly similar to the Morgan Stanley trademark. And then finally, the last case that I just wanted to briefly mention is one that was filed by Priceline. This raises really one of the most fascinating and sometimes controversial issues under the UDRP. I'm not going to say the domain name here, but you can see it on the screen, which includes a vulgarity, a profane word, a pejorative directed at Priceline. And so the issue is whether this is actually permissible under the sort of fair use doctrine of the UDRP. In other words, does creating a domain name like this actually allow the registrant to prevail under the second element of the UDRP because it has established rights or legitimate interests? These are often referred to as gripe sites. That is, a domain name registrant may have a gripe against a trademark owner. And in many cases, these are permissible. In this particular case, the UDRP panel found that it was not. And that was in large part because the domain name was not being used in connection with the gripe site. It was being used is in connection with this sort of pay-per-click site, as you can see here. And also the domain name registrant tried to sell the domain name according to the decision to Priceline and use it as leverage. So this resulted in a decision ordering transfer of the domain name to Priceline. So that is essentially what I wanted to talk about today. As you can see, I don't think we're seeing any slowdown in domain name disputes. We're seeing still quite the opposite because the UDRP is growing in popularity. There's another dispute policy that I don't have time to get into in detail, the URS, their Uniform Rapid Suspension System. But I think the number of UDRP and domain name dispute decisions will grow. We're seeing the same thing under many of the country code or CC/TLD dispute policies. And yes, I will acknowledge there is ongoing discussion about potential changes to or reforms to the UDRP system that both trademark owners as well as domain name registrants might like to see. This is a discussion that has been going on and probably will be going on for years. So do not expect any immediate changes to the UDRP system. So with that, I'm happy to take any questions.
Thank you for a very inspiring presentation. It was very useful, especially to me, who is giving lectures to the students on cyber squatting, and especially great example cases for typo squatting. And I will sure in the future take some of part of your presentation to them. Question that we get until now addressed for our panelists, and the rest of the conference will held on Serbian language. So this is the end of the part of the conference held on English, and we will now switch just on Serbia. It's up to you.
Hi, Doug. Can you hear me?
Yes, I can hear you.
Perfect. First of all, thank you very much for joining us this event. Your presentation was very good, and we appreciate your efforts.
Thank you.
Of course, as you can imagine, I have a couple of questions, but we are pressed with time, so it's I'm particularly interested in, you were talking about bad faith and the criteria for establishing bad faith on the side of the registrant respondent. And in having in mind your experience, in case keeping a domain name, for instance, for 5 years without any content, can we establish a bad faith element? Thank you.
Yes. Again, or I guess I should say, all these decisions, you have to look at the specific facts of each case. But I think what you're referring to there is what the UDRP precedent has come to establish as the passive holding doctrine. That is, what if a domain name is simply being passively held and is not associated actively with a website? And this is a question that was addressed very early on in UDRP decisions. And under certain circumstances, it is possible to establish the bad faith element even in the absence of a website or other information, such as it depends in large part on a number of factors, including the fame or the strength of the trademark at issue, whether a response has been filed, whether the registrant of the domain name is actively hiding its identity or may have a track record of engaging in other cyber squatting activity, and whether it's really possible even to think of any good faith uses to which the domain name could be put. So yes, under the right circumstances, it is possible to establish bad faith even where a domain name is just sort of parked or not being actively used.
Thank you.
You're welcome.
So now definitely switch on Serbian language. Excuse us for that. And now part of the conference that will held, as I said already, on Serbian language. Poštovane uvažene kolege, stiglo je više pitanja, neću vas pojedinačno predstavljati s obzirom da sam to već više puta uradio, kako lično vas, tako i kancelarije iz kojih dolazite. I prvo pitanje koje smo imali se tiče nečega što zaokuplja već duže vremena našu javnost, a to je usled generisanja ogromnog broja vesti koje se svakodnevno na internet portalima javljaju. Korišćenje autorskih fotografija je, kako je neko od korisnika postavio pitanje, nelegalno korišćenje fotografija regionalni problem. S obzirom da mnogi od mojih studenta, ali i ljudi koje ja poznajem, pronalaze na vašim web stranicama vaših kancelarija odgovore na ovo i slična pitanja, molim vas da date odgovore.
Hvala, Mario. Dobar dan svima i od nas iz panela. Što se tiče problematike objavljivanja sadržaja koji je, ajde da kažem, u režimu autorsko-pravne zaštite na internetu u razne svrhe, to pitanje se ponavlja iz dana u dan i to govori o tome koliko je ta tema aktuelna i koliko muči ljude. Kako one koji koriste sadržaj, dakle imaju želju da postave neki sadržaj, a ne znaju kako, ne znaju da provere da li je on zaštićen ili ne, tako i one s druge strane koji su mahom autori, a koji žele da zaštite svoja prava na sadržaju koji su kreirali. Dakle, u principu je jednostavno, mislim jednostavno, nije jednostavno, ali ajde da krenemo od jednostavne činjenice da sve što je postavljeno na internet, a uživa autorsku-pravnu zaštitu, dakle autorsko delo je, recimo fotografije, možemo da kažemo da je to neko stvorio, načinio i da je neko autor tih fotografija. Naravno, ukoliko autorsko-pravna zaštita nije protekla, dakle ukoliko nije prošlo 70 godina od smrti autora, ali u tom slučaju imamo isticanje samo imovinskih prava koje se tiču eksploatacije dela, a ona lično pravna ovlašćenja autora i dalje postoje i ona imaju tu neku važnost koja nije limitirana vremenom. Dakle, vodite računa kada objavljujete fotografije na internetu. Proverite ko je autor, ko je nosilac prava na tim fotografijama i tražite dozvolu ukoliko baš želite da objavite određenu fotografiju. U suprotnom, lako možete imati problem da neko od tih fotografa, autora, ne samo fotografije, prosto tu su i video snimci i razne druge forme autorskih dela, može da odluči da ostvari svoje pravo pred sudom, odnosno možete lako biti tuženi. Dakle, za one kojima treba fotografija da bi ilustrovali svoj tekst, svoj oglas na svom nekom blogu i tako dalje, pa na kraju krajeva i na društvenoj mreži, moj savjet je, imamo veliki broj takozvanih stock sajtova gde se nude fotografije ilustrativnog karaktera za određene, ajde da kažem, pristojne sume novca, zavisi od formata koji hoćete da preuzmete i za namene koje želite u kojoj želite tu fotografiju da iskoristite. Dakle, bolje platite $2-3 pa i $5 za korišćenje neke fotografije sa nekog stock sajta nego da se poslužite preuzimanjem, neovlašenim preuzimanjem fotografije sa interneta. Jer ukoliko je nešto dostupno na internetu, ne znači da je korišćenje tog sadržaja slobodno. I mi često govorimo neku analogiju sa realnim svetom. Intelektualna svojina je karakteristična za prosto neke bestelesne stvari, za neka prava, ali nekako ljudi bolje razumeju kada navedemo primer, kao što nećete posegnuti za nečijom stvari za koju znate da nije vaša. Ako neko ostavio bicikl parkiran ispred zgrade, nećete uzeti i odvesti se tim biciklom. Nećete uzeti ničiju stvar jer znate da nije vaša, znači nečija je. Isto tako se ponašajte prema sadržaju na internetu nečije. U poslednje vreme su se razvile licence kreativne zajednice, što je dobro, jer imate dosta sadržaja koji je u režimu ne baš slobodnom, zavisi koje licence su implementirane, ali veliki broj sadržaja je dozvoljen od strane autora za korišćenje, samo vidite pod kojim uslovima, da li je obavezno da navedete ime autora, da li je obavezno da li ste ovlašćeni da menjate ili sadržaj ili ne menjate, da li ste u obavezi recimo da isti režim autorsko-pravne zaštite primenite na sadržaj koji ste kreirali na osnovu takvog dela i tako dalje. U svakom slučaju ima alternativa, malo je sada vremena da tu temu obradimo detaljno, ukoliko nekog interesuje, možemo se posavetovati, ima toliko i sadržaja na internetu edukativnog karaktera i prosto može se doći do odgovora na dosta pitanja kada su autorska dela i njihova zaštita u pitanju. Eto, nadam se da sam odgovorio na pitanje. Hvala, Mario.
Ja bih se samo nadovezao na izlaganje kolege Dragana. Vrlo često kod preuzimanja fotografija, oni koji preuzimaju fotografije prave još dodatno dve povrede koje se, dakle, ne tiču samog preuzimanja fotografija, već kada preuzimaju, oni objavljuju i ne naznačuju ko je autor fotografije, a takođe vrlo često fotografiju menjaju tako što je umanjuju, kropuju, takozvano kropovanje vrše, prilagođavaju je, da kažem, svojim nekim povredama, tako da to su dodatne povrede moralnih prava samog autora, pored naravno one osnovne koju čine kada preuzimaju bez saglasnosti i bez davanja određene imovinske nadoknade za takvu vrstu korišćenja. Hvala.
Evo sledeće pitanje koje nam je stiglo. Pozdrav, interesuje me kako kolekcionarske predmete možete prodavati preko interneta. Pod kolekcionarskim mislim pre svega na nekoga ko sakuplja predmete, nije mu glavna namera da ih prodaje. I kaže dalje, veliki deo predmeta se nađe na buvljaku ili, na primjer, Kaleniću pijaci. To su uglavnom predmeti koji su stariji i koje više nikoga ne zanimaju. Često ih i sami pojedinci doniraju ili bacaju. Na primjer, stare fotografije, pisma, knjige, poštanske marke, privesci za ključeve, kasete i posebno bih pitao za muzičke ploče. kako dokazati vlasništvo na takvim stvarima, da li postoji neki oblik takve trgovine na internetu, kako je to regulisano. Hvala na divnom predavanju i informacijama. To je sve rekao jedan od korisnika. Izvolite.
Evo, mogu ja da pokušam da odgovorim na pitanje. Dakle, zakon ne kaže jasno gde je granica između trgovine, a gde počinje ona prodaja, ajde da kažem, kao što imamo u malim oglasima gde neko prodaje višak svojih stvari i tako dalje. Tu je vrlo osetljivo pronaći tu granicu u smislu što ukoliko se neko bavi prodajom kao delatnošću, ukoliko ste kolekcionar i imate veliki broj određenih stvari koje ste prikupili, naravno pod uslovom da njihov promet nije ograničen u smislu da nemaju vrednost kulturnog dobra i tako dalje, to da izuzmemo, ali ukoliko imate veliki broj toga, vi teško da ćete moći da se provučete kao da prodajete svoje lične stvari u oglasima, kao što možemo imati, možemo izvršiti uvid u raznorazne ove web sajtove, raznorazne platforme koje predstavljaju neki vid ili povezivanja kupaca i prodavaca ili nude oglasni prostor i to je sve ok, dok ne ode u zonu trgovine. Kad imate dosta posla, u smislu dosta prometa preko računa, dosta klijenata, dosta stvari koje prodajete i tako dalje, vi upadate u oko inspekcijama i zalazite u teren trgovine i vrlo lako možete biti na njihovoj meti, jer onda možemo i ući i u onu drugu priču, u eventualno ostvarenje bića krivičnog dela nedozvoljena trgovina, gde su zaprećene kazne do 2 godine za neka bazična krivična dela, pa čak i do 5, zavisno od toga kolika se imovinska korist ostvari i tako dalje. Dakle, vodite računa. Jasno mi je da se neke stvari tolerišu u praksi, da vi možete naći prodaju vinil ploča, vinila na ulici i tako dalje, pa pomenuli ste i buvljak i sve je to u redu. To što neko svakog dana ima neki štand negde pored nekog puta, to što se to toleriše i mislite da se toleriše, ne znači da to tako treba i da je to zakonito. Verovatno ste mogli da vidite koliko puta dođe inspekcija, pa oni svi to što prodaju sklanjaju i tako dalje, da im ne bi bilo zaplenjeno i da protiv njih ne bi bila podneta prekršajna, odnosno krivična prijava. Dakle, vodite računa, dokle god je to prodaja, da vi imate, ne znam, jednu stvar koju želite da prodate na internetu, da se rešite, kao što imamo, ne znam, razne web sajtove, to je okej. A da vam to pređe u neki vid delatnosti, onda to nije u redu i onda ste već trgovac, a trgovac, kako kaže zakon o trgovini, može da bude samo preduzetnik i pravno lice.
Izvinjam se, samo da dodam, ovo je, čini mi se, kolega, bilo adresirano pre svega na nedozvoljenu trgovinu, a ne na aspektu kome smo mi danas, ne mislim kao zamerku, nego čisto razjasnimo, zato što ste vi sa pravom mislili da se podrazumeva da ovaj deo, pretpostavljam, da ovaj deo kada pričamo o pravima intelektualne svojine je nešto odvojeno od ovoga, pa ste u to ime adresirali sve u delu koji se odnosi prevashodno na nedozvoljenu trgovinu.
Apsolutno, to je tema konferencije i onda...
Da, dobro, samo da...
Da tu temu na takav način i prikaže.
Neke stvari koje se među nama profesionalcima podrazumevaju, nažalost, nisu uvek shvaćene na pravi način od publike. Izvolite, kolega. Ćete vi? Dobro. I imamo poslednje pitanje koje je stiglo za sada, to je jedan od ovde učesnika je preformulisao zapravo pitanje koje je bilo adresirano kao prvo i to je pitanje koje se odnosi na kako u očima našeg zakona za prodajom nošene markirane robe postoje sajtovi, registrovane prodavnice koje prodaju takvu robu, oglašavaju kao, na primjer, polovni, Chanel i tako dalje. Ovo je otprilike nastavak ovoga. Izvolite. Evo ovako. Kako je u očima našeg zakona regulisano prodaja nošene markirane robe? Postoje internet sajtovi, registrovane prodavnice koje prodaju takvu robe ili oglašavaju kao polovni Chanel, na primjer, i tako dalje.
Da. Jel se čujemo?
Pa dobro je pitanje i to je verovatno jedno od onih životnih pitanja koje muči mnoge. Koleginica Olivera Medenica se dotakla tog pitanja i mislim da ga je jako lepo obrazložila u svom izlaganju. U suštini, dokle god, znači to pitanje ima zapravo dva aspekta. Jedan je pitanje dozvoljenosti trgovine na način kako je kolega Milić objasnio. Znači neko ko ima intenzivno, ko to radi u vidu delatnosti, ulazi u pojam trgovca i podleže jednom posebnom zakonskom režimu i mora da ispunja uslov, između ostalog da bude i registrovan kao trgovac i tako dalje. Mislim da ne ulazim sada u taj aspekt. Pretpostavljam da fokus ovog pitanja nije bilo na aspektima ispunjenosti uslova za trgovca, već pitanje kako zakon naš tretira prodaju polovne ili second hand, kako se već to popularno kod nas naziva, stari srpski naziv, te robe. Sad, tu se treba napraviti razliku da li je u pitanju polovna roba koja je originalne prirode ili je krivotvorena, ili kako mi volimo kažemo, da li su kopije. Lažnjaci, fake, kako se popularno različiti nazivi postoje kod nas. Znači, dakle, ako se radi o polovnoj robi koja je originalna, znači koja je svojevremeno bila kupljena, na primjer, u prodavnici u Francuskoj, na primjer Chanel torbica, najjeftinija Chanel torbica je nekoliko stotina evra, neko je to nosio, odlučio je da proda na Instagram profilu ovde kod nas kao polovnu za recimo 20 evra. Pošto se to jako dešava, imaju i profili, torbice se prodaju sa popularnim i luksuznim modnim brendovima za 10 evra. Prodaja takve polovne robe koja je znači originalna bi bila dozvoljena sa aspekta prava intelektualne svojine. Znači to je dozvoljeno. Međutim, ja ovde hoću da ukažem na jednu pojavu i da ljudi ne nasedaju na to. U većini slučajeva, u 95% slučajeva, iza takvog oglasa polovna original Chanel torbica koja je 20 evra, pa se čovek vodi time, ok, 20 evra je Chanel torbica zato što je polovna. Ta torbica 99% da nije originalna. To je fake, to je kopija. 99% slučaja. Mislim, čisto da ljudi obrate pažnju na to da ne nasedaju na takve oglase. Nema nove Chanel torbice ili sličnog modnog brenda Gucci, Louis Vuitton i tako, ne postoji torbica za 10-20 evra, ne postoji za 50 evra. Polovna, eventualno da, ali ja vam kažem ono što govorim vam iz prakse advokatske, kako stvari funkcionišu kod nas i u svetu, iza takvog oglasa stoji fake, stoji lažna roba, stoji kopija ili krivotvorena roba.
Ako nemamo više pitanja, jer nemamo, čini mi se, onda smo iscrpili sve teme za danas. Veliko hvala svim učesnicima, ogromna zahvalnost i RNIDS-u na sjajnoj podršci, zadivljujućoj tehničkoj podršci i svemu ostalom da bi to funkcionisalo na način na koji je funkcionisalo danas. Hvala panelistima koji su bili deo organizacionog odbora ove konferencije i vidimo se do godine. Prijatno.